out of North Carolina, who is the manager for the NDO, is suffering with COVID right now. She thought she was going to be able to get on, but she's not feeling well. So I told her that we'll catch her at another time. With that said, I just want to follow up again. Like we said, we would do it every 2 weeks to just come together to talk this out so we can make the right decision to have a program that will be friendly to everyone, business, community, and anyone who comes or live and enjoy Augusta. At our last meeting, I think we forwarded the draft NDO that we had for Augusta. And I wanted to just ask if anyone had an opportunity to look at it, and do you have any feedback for us, or if you had another program that you have been looking at that would shed some light on what we are trying to do here in Augusta. Okay, Commissioner Johnson.
Thank you, Madam Chair. I did have an opportunity to look deeper into our ordinance, draft ordinance, and sort of get an idea of where some of our changes needed to be made based off of some of the conversations that we had in the past. And I think that there's a general consensus from those on the working committee to enact some type of filing fee for here. I'm not sure which direction we want to go into today, but I think that the committee, and it's again strictly my opinion, I think that the committee is in a good position to go ahead and perhaps start directing legal to drafting, to making some of the changes based off of what our recommendations are. So I think one of the biggest things here would be to enact the filing fee. I'm not sure we agreed to what that filing fee could be. And I think we said anywhere between $50 to $100. I'm sure that'll be left up to the committee to decide. But just a couple of changes in the enforcement section outside of the filing fee. I think we also had conversations around which department this would go to. I think compliance is definitely the right place to go, being that they are well versed in the world that we're trying to address. One thing that I would suggest to the committee, and I'm sure, Madam Chair, we could discuss this, is that that we move towards the hearing officer model versus going the route that's presented now. I think that if we went the hearing officer model, that will give our compliance department the opportunity to designate that hearing officer. So a complaint is filed within the compliance department. The compliance department, perhaps the legal representative from the city that represents compliance, could thumb through the claims to see what is valid and what is not. All valid complaints could then be forwarded over to a hearing officer that is appointed by that the hearing officer could be our compliance director or the compliance director's designee. And then from there, our enforcement continues. But I think for the sake of this meeting and conversation, as far as enforcement goes, I would suggest that the committee would adopt a filing fee anywhere between $50 and $100 based off of whatever this committee thinks is feasible to folks who may feel discriminated against. And then the filing office, so to speak, being compliance with the legal representative that represents the compliance department, being that person that thumbs through the claims. I don't expect us to have many claims, which then would not give that person, hate to say much work to do because I can't gauge that, but compliance being the office that it goes through, the legal representative thumbing through the valid claims, and then those valid claims going to a hearing officer that is designated by the compliance director. Those are just some changes that I would suggest today. And again, Madam Chair, that's completely up to you to decide for discussion, but that's my input. And I appreciate the opportunity.
Okay, Mr. Duncan. Oh, I'm
Yes,
sorry.
Madam Chair, thank you. I agree with what Commissioner Johnson has said. I do think a filing fee is warranted. If there's not a filing fee, you always want somebody to have skin in the game. But I would prefer that it be kind of on the lower end. I think being around $50 would be sufficient, particularly if we're talking about individuals who are working close to minimum wage. We don't want that filing fee to be something that is so burdensome that they cannot bring the issue to the compliance department because they just don't make enough money. But I do believe a filing fee and is appropriate. And the compliance department and a hearing officer, I support both of those issues.
Okay. Ms. Parr?
Yes, good afternoon, everyone. And thank you again, Commissioner Scott, for holding these meetings. I would concur with Commissioner Johnson in terms of the filing fee. We have the chamber taken a position that we feel it's important to at least ask complainants to file a fee. I think it should be on the lower end of the spectrum as opposed to the higher end of the spectrum. I think that $50 is certainly a number that I think everyone could achieve. In terms of the compliance department / hearing officer, I think that is a great way to go. If you look at other ordinances throughout the state, there is a person that reviews the claim for its all of the information that is required and makes a determination as to whether it should move forward. And I think that would be very appropriate. I was wondering, Commissioner Johnson, if you had a sense of how long. I know the compliance department has a lot on their plate. I know that from the business community's perspective, time is always of the essence on these matters. And I don't know if we could implement some kind of time frame that at least a business and the complainant for that matter would know how long it would take for that review.
Madam Chair, do you mind if I chime in on that?
Yes, Mr. Donna, and then Mr. Johnson, Commissioner Johnson.
Oh, I'm sorry. I didn't know that Commissioner Johnson was in the queue. I can wait until after he goes.
Oh, I yield to you, Administrator Donald.
Well, I think on that piece, I think as you create you'll create an ordinance, but you'll have standard operating procedures related to how soon that would occur. I think it's a great question by President Parr, but I think once you determine that the hearing officer is the way that you want to go, as well as the $50 is the filing fee. It sounds like that's consensus. Don't want to make an assumption, but if it is, what staff would do, and I don't want to speak fully on behalf of legal, but I'm sure staff members would have a say in that. We would look at other ordinances that are similar. Savannah definitely comes to mind, and I think they spell out, if I'm thinking off the top of my head, I want to say it's about 7 business days that they get a response, or they say 3 to 7 business days. And so if that's the case, we might model something similar to that, whatever those best practices are. But I don't think you have to legislate that at this time as a part of your recommendations versus ensuring that a timeline is included in the ordinance.
And Madam Chair, that was exactly what I was going to say. So Administrator Donald covered that to the T. Thank you.
Ms. Johnson, did you have something to say? I see you.
Well, I was thinking that it would probably follow somewhat of the guidelines that our EEO policy is doing right now. There are timelines within our EEO policy that states that the complainant will hear back from us within a certain amount of days. And I would see that ordinance following that same guideline.
Okay. And I briefly spoke with Savannah yesterday, and the clerk said that since they have enacted the NDO, they have not had a complaint. And he said that he didn't know if it was that people didn't know about it or what it was, but for right now, there has not been any change in people calling. And, I think that was one of the concerns were if people start flooding the gate with perhaps just being mad and just say, I'm gonna do something and do it, but they had not seen any changes. My counterpart in Orange County, North Carolina, they have had a program for a while now, and they are not getting a lot of reports or want to file a grievance either. In fact, they have 2 resolutions since they enacted their NDO with some other types of perhaps discrimination. But as a rule, as long as they've been in existence, they may get 1 a year. And so that's in something as well. Mr. Duncan?
Yes, Madam Chair, thank you. I think that's a good point. I'd also like to make kind of the opposite point, is that if just because there are no complaints doesn't mean that it's not necessary.
Right.
I think
Right.
when you have a law, most citizens and probably more businesses than citizens, Ms. Parr would probably agree, follow the law. They do what they're supposed to do. And the existence of the ordinance itself might reduce the instances of discrimination itself. But even if we have no instances where somebody brings a complaint, as Ms. Willard brought up at the last meeting, it's a positive marketing element for the city to show that we have this. So even if it's not used, it's going to be very beneficial for the community.
Right. Commissioner Johnson?
Yes, ma'am. Thank you, Madam Chair. I would like to just make a suggestion to the committee that if we are in a place to where we're comfortable with the filing fee and certain components of the enforcement portion, that we perhaps agree to have our ordinance mirror Savannah's ordinance. I mean, it seems as though we have a general consensus that that's a pretty cut and dry ordinance. I would suggest that we go that route, enacting the $50 filing fee. And then, of course, where the enforcement piece is coming from, we just add in our language with the compliance department being our filing center, so to speak, looping in the necessary staff. Because again, some of the concerns that we had was, we don't want to make Ms. Johnson's job any more complicated than what it already is. If we can avoid hiring additional people, we certainly should. But I think that Savannah ordinance would get us to a place to where it can avoid as much heartburn on our end where we're drafting the ordinance, and then on hers as well in enforcing. So I would suggest that we adopt the Savannah ordinance, that we agree to modeling our ordinance after the Savannah ordinance, adopting a $50 filing fee, and compliance is our hub. And I'm not sure we need a motion for that or whatever, but I would just submit that for discussion.
Ms. Parr?
Yes, Commissioner Johnson, I think that's a great recommendation. I also feel that one of the points that we made in our first meeting was, on behalf of the chamber, the process through which the draft ordinance utilizes the magistrate court is potentially very cumbersome for the business community. And so I know the Savannah ordinance, once the hearing officer reviews it and it goes through a mediation process, it returns to a hearing officer who makes the final determination as opposed to using the courts to adjudicate the process. And I think that is preferable. And also the way that it is modeled in the Savannah ordinance. Thank you, Madam Chair.
Mhm. Well, I think we all in agreement with that, and we certainly can go forward. I think with that, I think, and then of course it'll have to go to the full commission anyway for what we have to do. But I think it could be the recommendation of the working group that we want to lay these, the filing fee, the enforcement to compliance through a hearing officer, and change and look at the timeline as well, and take out the courts at this time.
Madam Chair? May
Yes,
I
sir.
just wanted
Yes,
to,
go ahead.
I mean, my screen isn't working, so I hate to be chiming
That's
in.
all right.
But I think since you are an official subcommittee, I think you would need to take some action on those items. So you could basically entertain a motion, and I'll defer to Madam Clerk on this, but I think if you entertained a motion to ratify Commissioner Johnson's action, then you can add it to either the next, and I don't know if it would be the committee cycle or the next commission meeting, because I think y'all decided to do this at a commission meeting. I would definitely defer to Madam Clerk on that. But if you took action on it, then it would be your formal recommendation back to the committee to the commission, who could then vote to move forward in that manner.
Okay. Ms. Bonner, are you available? Or Mr. Brown, Attorney Brown?
Yes, ma'am, I'm here.
Yes,
I
ma'am.
concur with that. You can make your recommendation directly to the commission, since this working group was appointed by the commission. And so that could happen. However, if you choose to go through committee, you have that option as well. But
Okay. Attorney Brown?
Traditionally matters. Technically, I think Ms. Bonner is correct. However, I think it should go through a committee process where commission have discussion, not just go straight to the floor for the commission then to have to discuss it, debate it, or maybe send it back. I think it should go through a committee. Technically, though, it could go to the commission, as Ms. Bonner has said it, but I think you need to allow the commission to have some discussion on it before it really gets to the full floor for the vote.
and I agree with that, Madam Chair, if I could, what Attorney Brown is saying. That's usually where the commission usually hash out all of, maybe if there are any indifferences that's going on, other commissioners who have not participated in the working group committee may have questions that they may not be aware that you've already answered. So most things are hashed out through the committee process. And when it usually reaches the commission level, it's pretty much settled because all of the commissioners have had an opportunity to weigh in. So that approach would be in order as well.
Yes, ma'am. Okay, I'm gonna go to
I think Mr. Brown had his hand up.
Mr.
again.
Brown first.
Yes, ma'am, thank you. I just want to ask exactly what is going back to the commission?
To adopt. May I? Okay.
Go ahead.
Okay. The recommendation, Attorney Brown, apparently from the commission is to adopt, for Augusta to adopt the Savannah ordinance as a model, with compliance department handling the initial filings with the law department involved as the hearing officer. And then it's adjudicated that way. But the Savannah ordinance would be the model by which Augusta would proceed.
If I could jump in and make one small adjustment to what you just said, Ms. Bonner, Madam Chair.
The filing
ahead.
fee, okay.
So the legal representative for compliance, and Ms. Johnson or anybody, please correct me if I'm wrong, the legal representative for compliance would not necessarily be the hearing officer. They will be the person to decide whether a claim would be, well, I guess that would make them the hearing officer. The person would decide whether or not the claim is valid or not. So okay, so technically that is the hearing officer. Okay,
Right.
got you. But I think it should be added into the ordinance saying that it can be that attorney or the compliance director's designee. Unless there's some unreadiness about that.
Attorney Brown.
Well, frankly, I'm either unready or I disagree I disagree with that idea.
Okay.
Of course, the commission, this body can recommend what it likes, and the commission can decide what it likes. But I would think the next step would be, usually part of Georgia law is that when a body votes on something, a document should be there before them. There's a requirement of presentment. Right now, the document that you are recommending is not before you. I think the document needs to be drawn up, come back to another meeting to make sure what we're recommending or what we put in there is what you think you are saying, or what I think I hear is what you have said. And I hear what you're saying, that the major structure of the ordinance should be patterned after Savannah. I think we need to actually draw it up and work the kinks out so that the members of this group have a meeting of the minds. So I think if we see it in writing, then this body will know exactly what's going to be presented. I would hate to present something and then some member of this working group go approach their various commissioners and say, no, that's not what I meant. That's not what I said. I would like for the body to be solid on what it wants to present. I also have concerns because it's not clear to me what's being recommended regarding the law department's participation. We have to make sure now the law department is a unit that represents the commission, the governing body. We are not hearing officers, we are not judges, and we are not solicitors. We are not prosecuting anything. So while we will try to draw it up, I need a little time for me and my staff to think about, will this somewhere down the line put the law department in some type of conflict of interest? We don't want to be blocked from representing Augusta in some kind of way by getting in the middle of a specific charge of our codes being enforced. So I do have some concerns about that. It may be okay, I just can't see it right now.
Okay. Commissioner Johnson, did you have
Yes, ma'am.
something?
Yes, ma'am. My question is for Attorney Brown. How
Yes,
long
sir.
do you think that that you would need? What type of time do you think that you would need to get that draft to this work group with all the I guess the unreadiness worked out? What time frame are you looking at? Or what time frame would you request us, consider for you?
I would imagine 2 weeks would be fine.
Okay. So by the next work group meeting?
Yes, whenever that would be scheduled.
All right.
And Madam Chair, if I could, I would like to hear from Ms. Johnson, if you deem appropriate, maybe to attempt to address Attorney Brown's question about the law department's involvement in this whole process. If Ms. Johnson, if she would.
Okay, ask that question again.
That's the question of Attorney Brown. His question, and I don't want to speak for him, but it was around the lines of what role would the legal department play in enforcing the non-discrimination ordinance from a hearing officer perspective?
Well, I guess, like I say, I was looking at everything to flow just like our EEO process does. And they only get involved if it's a legal matter. Other than that, the law department is not involved.
If I may, Madam Chair. Commissioner
Yes,
Scott.
yes, go ahead.
Yeah, I concur with that. Knowing what we do, we provide legal support and guidance for the administrative staff. Compliance, while it has a legal effect, compliance department is not the same as the law department. Making sure that matters brought to compliance are handled is a function generally of the compliance department. We provide legal services to compliance the same as we do to HR, to the administrator's office, to procurement. We don't step in and then do procurement activities. And I do not think the law department should, even though we may be able to, start doing administrative compliance work.
Madam Chair,
Yes, sir.
maybe this question can go to legal counsel or administrator. So in that regard, would it make more sense to not say that legal representative will be the hearing officer, and that the hearing officer could be the compliance director, or like I said before, her designee, his or her designee, because I know Ms. Johnson is a different conversation. So Ms. Johnson's designee versus specifically saying the attorney, because if we're saying that would complicate that would present certain issues, which I'm sure that, I mean, it's a valid point. Could Ms. Johnson be that person, or she designates someone who she feels has the skill and know-how to determine what's valid and what's not? I guess that could be a Attorney Brown question or Administrator Donald question.
I see you, Attorney Brown, but let's go to Attorney McLean-Heyman. Go ahead.
I just had
Go
a
ahead,
question
Mike.
too. I didn't have a
Okay.
comment, I just had a question.
Yeah, I just wanted to briefly chime in because I'm hearing the committee say that they want this ordinance to mirror Savannah. But if I recall Savannah's ordinance, the hearing officer is an attorney that was hired by the city to specifically handle those charges. So those complaints. So it's a mute. This issue is mute, because if you want it to mirror Savannah's, then all the compliance department have to do, or the city would have to do, is just contract out with another attorney. And that's how Savannah's ordinance operates. Okay.
Mhm.
Well, I know that there had been conversation about not doing that. So we know my comments have only been just trying to get us around that initial recommendation from, I believe, our first or second meeting. But I would be interested in hearing from our administrator. But that's absolutely correct, Ms. Heyman.
Madam Chair, do you mind if?
Go ahead.
Yeah, I think I would kind of respond back to just highlight, I think if your recommendation is to have a hearing officer, I think the details can be worked out by your staff leaders, meaning my office, the attorney's office, as well as the compliance office, on what the actual procedure looks like. I don't think they name a hearing officer in the Savannah ordinance. They just name that there is a hearing officer. And so that gives you the flexibility to then appoint a hearing officer, contract it out, name someone after implementation when you develop your standard operating procedures. But if you use that model and you know that you want a hearing officer, I think for today's conversation, it's important to hit the high points of what you want to see in the ordinance, and then allow your staff to bring back the details necessary for the document for your review, and then you can tear it apart, add things, remove things, and adjust as necessary. So I definitely don't want to stop the momentum, but I think what you're asking for is big picture and strategic, which is great. And then the detail you would have your staff bring back to you at that future meeting.
Okay. Attorney Brown, did you say you have a comment?
Yes, I do. At first I had a question. I was, I see Savannah says in here that a hearing officer is an attorney. I wonder if this body would want also to consider an attorney or otherwise qualified person. I think ideal for this type of position could be an attorney, but it's really more important to have somebody who has some competency in employment law or EEO matters. Sometimes you have EEO officers who have worked for the EEOC. I think they will also be excellent. A lot of attorneys may do employment law, but they're either defending or, for lack of a better word, prosecuting or being plaintiff's attorney. But to the actual administration of EEO matters, EEOC, high-level experienced EEOC officers also could possibly be very efficient candidates as well. And I have no problem saying will be an attorney and or otherwise qualified individual to leave room for more than just an attorney. An attorney will hear things and make a decision. Just because you're a lawyer, it doesn't mean you know everything.
Really?
Wow.
Really? Really? Really?
What a self-declaration.
We're gonna hold you to that, Attorney Brown.
I think I had a brain freeze or something.
Too late. It's recorded. It's recorded.
Motion to recall statement.
Yeah, right. Okay.
Madam Chair.
Go ahead.
Thank you. So would it be in order to simply today move forward with having the Augusta draft ordinance mirror Savannah's with the filing fee at 50, with the compliance department being our area, and then spelling out that the hearing officer, along with what Attorney Brown just said, the hearing officer be someone, an attorney or otherwise, someone otherwise qualified. Are we in order to do that? And then would that require a motion, or would that just require a simple, consensus of those on the call today? I mean, how could we move forward with that in some way? Attorney Brown, maybe your opinion, even though attorneys don't know everything.
Yeah, I would just, I would just say.
So we'll go to Ms. Bonner.
She knows everything. I would just say, I think you don't have to be so formal in larger organizations and larger bodies. Robert rules usually are done to help create order so you don't have chaos. But in smaller groups, even Robert rules would say you can relax rules of procedures. So I think if it's the consensus of this body that your next meeting will be to review a draft of a Savannah-like ordinance pursuant to the conversation that you had today, I think we could say that's how we will move forward without objection. And I think that's all you would have to do.
So do we have consensus?
For
Do we
me,
have
it's-
consent?
It appears
Yes.
that it's there,
Yes.
Madam Chair.
Okay.
Yes, Madam Chair, if you're looking for consensus, I would agree with that.
I would agree also.
Okay. Well, we got through that part, huh? So is it
Well-
anything? Ma'am?
No, it's just gonna say, it's just a matter of Attorney Brown bringing back the document for your review. So that's simply all he's asking. He's asking today.
And so that we can give him, is it anything else we need to discuss? And I don't know, do we have anybody on a call in, Ms. Bonner? Can you see that, or IT?
Yes, ma'am. What is it you need?
I was wondering if Reverend Woods or Morris Porter was on. And I didn't know
Morris,
if
yeah, Mr. Porter is on. I do not see Reverend Woods though,
Okay.
but Mr. Porter is on.
okay, all right.
Are you in concurrence, Mr. Porter?
Yes,
Okay,
I gave the thumbs up.
I didn't see it. I'm sorry. Thank you.
Yes.
All right.
Can I ask, this time frame that we all going to receive a draft of the Savannah adopted ordinance with the changes, and then review it as a group?
Attorney Brown.
If I may, Madam Chair, I would suggest that if you set the meeting 3 weeks out, we will be able to send out a draft within 2 weeks. And so the members of this group will have a week to review the ordinance and to be able to make his comments.
Okay, what day is that? Because I was definitely not gonna have
3
it on
weeks
the-
out may conflict with Mr. Johnson's homeless task force if we go out 3 weeks.
I didn't necessarily mean to the day or
Okay.
time.
Your meeting is the 14th, Commissioner Johnson?
Yes, ma'am. We can stick with the 3 weeks. I don't think we'll have much of a conflict. We can stick with the 3 weeks.
Is that enough time, Attorney Brown and Administrator Donald?
I think it is.
Because I know you
for us.
gotta,
Ms. Hayman, unless, Ms. Hayman,
because we can go out,
2
I
weeks
think,
is good. No, Madam Chair, you could set it, well, if you like to have one meeting a month or something of that nature, we can set it to whatever you want to. We just want to be able to give 1 week's notice, 1 week notice to the members of what the ordinance really says.
okay.
So for clarification, you want the ordinance to be, the draft to be circulated among, well, I can send it to the chair, and for everyone to make revisions and then for it to come back to legal?
No, I believe what we're going to do is try to take what we believe we heard, draft it, and send it to the chair and Ms. Bonner, and the chair will decide the distribution. And so when the body got back together, any changes they may want to be discussed then. Is that okay, Commissioner Scott?
Yes, as I want to give you all time now.
Two,
So you would 1, 2, 3. If it's due back on the 14th, that will be our next meeting. Am I correct? That will be
Yes.
fine. Yeah, we had 5 Thursdays in September. That's what threw me off. Commissioner Johnson's meeting's on the 21st. So that would give you the week of the 27th, October 4th week, and the 11th through the 14th. So you want to say have the ordinance ready? Can you have it ready the week of October 4th, Attorney Brown?
we'll have it within 2 weeks of the day, which would be the 7th.
Yes, sir.
Yes, ma'am.
That's that week. Okay.
Yes, ma'am.
Okay.
Okay, all right. I think that's good. Any other discussion, comments?
I think, Madam Chair, when we pass this ordinance, it should be named the Wayne Brown Anti-Discrimination Ordinance.
No, please don't.
All right, okay. Well, thank you so much for coming. Thank you, Ms. Bonner, as always, for setting this up, and thank you for all your time.
Thank
And
you. You're welcome.
all right, thank you all.
Have a good rest of your day.
All right.
Bye
Okay.
now.